All right, good morning. Let's go ahead and get started. Try to stay on time as we did yesterday. Today, we're here to start off with the future of the CISG. Have we come to praise it or bury it? I'm guessing we're probably here to praise it, but we'll see where things go this morning. And by the way, I'm obviously not Ulrich Magnus. He and I have switched, and I'll be moderating this morning, and he'll be moderating the second panel. So our first speaker is one of those where the challenge of introducing someone you all of course know, Professor Dr. Ingeborg Schwenzer, who has been one of my two, as someone who has been working with the CISG for 15 years, really has been one of my two guiding lights. Harry and Ingeborg, whenever I've got a question, and sometimes they may agree, sometimes they may disagree, but those are always the first sources for I think almost all of us. Since becoming Professor Emeritus at the University of Basel, Ingeborg has, of course, kept her hand in this and has started and remains the Dean of the Swiss International Law School, which is something else that's near and dear to my heart. It's online legal education. So she and I are again, kindred spirits in helping more and more people learn about the CISG and access the CISG when they might otherwise not be able to do so. Ingeborg continued until recently to chair the advisory council on the CISG. So again, Ingeborg is a luminary among luminaries, and we're privileged to have her begin our panel this morning. Ingeborg.
Thank you so much, Jack, for this very kind introduction. And let me start with thanking Ron for organizing this conference and for inviting me. I think it is a really proper possibility to honor my dear friend Harry Flechtner and to praise all his achievements. I'm very happy to be here, Harry. Today I'll talk, as relating to obligations that are not storable, intangible, non-tradable. In modern times, in economics, the boundaries are blurring. And this goes hand in hand with the rise in the prevalence of service contracts in international trade. According to WTO figures, the service sector amounts to 71% of the global GDP nowadays. So I ask myself, why does the CISG exclude service contracts? So I went back as far as to Rabel's seminal work, Recht des Warenkaufs, that was the basis for his work on the unification of sales law. I couldn't find any hint to service contracts. Likewise, in the Uniform Law on International Sales of 1964, the Hague Convention, there is no discussion about service contracts. What I could find is in the materials of the Vienna Conference in 1980, there was a Czech proposal, actually, to include service contracts in the convention because there is, according to this Czech proposal, there's no reason to exclude service contracts. This proposal was clearly rejected. Those who rejected it either did not provide reasons or just stated that it would be undesirable to include service contracts. So I couldn't find any convincing reason why service contracts were not included. Well, I think the reason behind this, no one wanted to jeopardize the universal adoption of the CISG and to open up a box of Pandora would not be advisable at that stage, yeah, if service contracts were included. So, and I think the reason or the emotional reason probably behind this is that the difference between sales and service contracts is deeply entrenched in domestic law. And that is why, at that time at least, in 1980, no one was able to take the hurdle and to mention the similarities between sales and service contracts and to work on this question. Well, just a few words about the domestic distinctions. The distinctions goes back to Roman law between sales and services. The basis for distinctions is not very clear. We do have in most sales laws around the world, we do have a definition for sales. Sales contracts are an exchange of goods for price. And if you look even into the civil codes of the civil law countries, you find as a definition of service contracts, a service contract is a contract for the supply of services. Okay, that helps a lot. If we look into domestic laws in common law countries and in civil law countries, you may either distinguish between sales and services according to the substance of the contract or to the gravamen of the action test. Very often, if you look into case law, the definition is clearly outcomes-based, depending on what you want. There are differences as regards form requirements, especially in common law countries, also in the US. There are differences regarding statutes of limitations. So whatever you prefer, you say either it's a sales or it is a service contract. Nowadays, there is a broad consensus among civil law countries and common law countries what contracts we call service contracts. I don't want to go into this. Let's have a short look at the consequences of classification in domestic laws. Sale of goods law is very well settled around the world in civil law countries, in common law countries. And what I find fascinating is that in common law countries, sale of goods was the first contract to be codified. In England and also in the Uniform Sales Act in the United States already in the 19th century. Whereas the supply of services law is largely uncodified. And this does not only apply to common law countries, it also applies to civil law countries. If you look into the civil codes and you compare the provisions on sales law and on services law, The sales law provisions are much more detailed, and in service law it's very vague, and you cannot find, you very often have to go back to the general law of obligations because you don't have any special rules for service contracts. I already mentioned there are differences as regards form requirement, there are differences as regards limitation periods, and there are differences as regards the basis for liability, especially coming from French law. We distinguish between obligation de résultat, obligations of result, which is a sales contract, but also a contract for work and labor, and so-called obligation de moyens, that means obligation of means, which are pure service contracts. And that has consequences as regards the basis for liability. We have differences as regards the remedy, especially in most civil law countries, price reduction as a remedy coming from Roman law is only possible in sales contracts, but there is one new development. France, in its 2016 amendment, has taken the remedy of price reduction out of sales law into the common general rules on law of obligation. Now price reduction is a possible remedy for all kinds of contracts, including services contracts. Now let me turn to the question, is the CISG suitable to govern service contracts? Well, I really have been thinking about it a lot, and I can find no convincing reasons why the CISG should not govern service contracts. And indeed, mixed contracts are governed by the CISG. We already saw Article 3, Para 2, if the preponderant part is the delivery obligation, then the whole contract is governed by the CISG. Not only the sales part, but also the services part of the obligation, which makes it very easy. For example, I was involved in a case, the electrification of the Sinai Peninsula. And so the seller did provide not only the cables, the electric cable, but also provided instruction services, trained the employees of the buyer, and supervised the erection of the poles and the fixing of the cables. Well, in the end, it just didn't work. But it was not clear. Why didn't it work? Weren't the cables suitable for this kind of climate in the Sinai Peninsula, a desert climate? Or weren't the people not trained properly? Or was there a lack in supervision? So you couldn't tell in the end, but you could tell there was a breach of contract. Yeah, it didn't work. So it was easy. We didn't have to decide which duty was breached. Was it the delivery duties, the sales duty, the conformity of the goods to the contract? Or was it a service obligation that was breached in the end? The essential question was that the whole thing was not fit for purpose. So I think this makes the CISG so much easier to deal with these problems than under domestic law. Under any domestic law, first you have to decide which obligation was breached. Was it the service obligation, or was it the sales obligation? And depending on this classification, then you have different results. So Article 3.2, if you have the preponderant part, that is the delivery obligation, you apply the CISG to the services obligations. If the services obligations are the preponderant part, you are out with the services obligation. What if you have two different contracts, connected but still different in two instruments? Then you have a sales contract and a services contract. Then you have to apply CISG to the sales contract and domestic services law to the services contract. I think that similar problems call for similar solutions, and that is why now I want to discuss with you whether the provisions of the CISG are suitable to govern service contracts. Let's firstly start with the requirements to establish liability. Well, breaches of contract may occur in form of non-performance or delay. In many civil codes of civil law countries, these questions are dealt with in a general part of obligations. That means they are applicable to all kinds of contracts, sales and service contracts alike. So also under the CISG, I think there's no problem in cases of non-performance or delay to apply the CISG provisions to services contracts. It gets a bit more complicated when it comes to non-conformity, especially in civil law countries, but also in the statutes on supply of goods. In common law countries, we have special rules for sales law. These rules in civil law countries go back to Roman law, and also warranty and all that stuff goes back to almost the Middle Ages. So they have been developed for a very long time. I think still the provisions on the CISG on non-conformity, that means Article 35, are well suitable to deal with service obligations. In 35.1, we have the question that decisive is the contractual agreement. I mean, that is applicable to service contracts as well. In Article 35.2, we have the provision fitness for particular purpose, fitness for ordinary use, sample or model. All this might occur in a service contract as well. You know, you have fitness for a particular purpose, for ordinary use of services. You can apply this provision likewise. Third-party intellectual property rights, Article 42 CISG, a provision that is unique to the CISG and differs from any domestic legal systems. I think this also would be proper for international service contracts, where also infringement of intellectual property rights of third persons may occur. And finally, examination and notice. I think, why shouldn't we have them in service contracts as well? Why only confined to sales contracts? Civil law lawyers would say examination and notice is an expression of good faith. So the buyer should examine, and if he can see that the service is not in conformity with the contract, why not give notice and give the seller the possibility to repair its service obligation? Remedies. We have certainly no problems as regards the remedies of the seller against the buyer, which means the service provider against the party who is paying the price. There are just no differences. Controversial are the remedies of the buyer against the seller. I think specific performance in form of repair or replacement, this can also take place under a service contract, especially under a contract for work and labor. You can give the buyer the possibility to ask for a repair, replacement, and also the service provider might have this right in order to circumvent any avoidance of contract or any further damages. Avoidance, I think there are no special features under service contracts. I think the approach, fundamental breach of contract, is the correct one and is taken up also in the UNIDRA principles. Damages, I think also in principle there are no differences as regards sales and services contracts. With regard to damages, again, in civil law, civil codes, very often we have the damages provisions in the general part of obligations. I think also the exemption under Article 79 is suitable to be applied in service contracts obligations, and it is there where we can distinguish between the obligation de résultat and the obligation de moyens. We have to ask under Article 79, we have to ask whether it is an impediment beyond the control of the obligor. And under services contract, the sphere of risk of the obligor certainly is narrower than under sales obligations. Failure due to the other party, Article 80, no special features for sales contracts. Reduction of the purchase price, I already mentioned. Under French law, we now have that as a general provision for breach of contracts. And services as long-term contracts, I think they also can be dealt with under the CISG. We do have a provision in the CISG, Article 73, relating to installment contracts. I think this provision can be easily applied to any long-term contract, also services contracts. And with this, I conclude. First, there is no clear distinction between sales and services. There is no need to distinguish, in my view. I think we should have a single legal instrument, which is probably very far from being realized. It would yield more predictability for the parties, and that is what they need in international transaction. So my last point is, if we cannot achieve a single legal instrument, my recommendation to parties of services contracts is to opt into CISG. Thank you very much for your attention.
All right, our next speaker is Nevena Yevremovich, and Nevena she's going to talk to us and continue this theme about of online educators in the CISG, which actually, it struck me as Ingeborg was speaking, we've kind of got that theme running throughout this panel, which seems appropriate since we're here to honor Harry Fleckner, and Harry has even gone online in teaching the CISG. So again, in continuing this theme, Nevena is the manager of corporate learning at the International Association of Contract and Commercial Managers, IACCM, where oddly enough, she works with Vicki Rogers, who is another member of this group who obviously ran the PACE website for a long time. Nevena is also very much involved in helping to develop young arbitrators and to develop arbitration practice, including online arbitration practice. But I also have to mention a personal connection. I first met Nevena about 7 or 8 years ago in Zagreb, Croatia, where she was just starting as a student in an institute that we ran along with the University of Zagreb and the University of Pittsburgh in Croatia, and those of us who ran the program are all here today. And so I first met Nevena as a student in that program, and then I was pleased to hear that she had also come to Pitt to do an LLM. And I think she may be the only person who was a student in both. We had someone who was an administrator in Zagreb and a member of the LLM program. And so again, it's truly a pleasure to see Nevena back here, and she'll be talking to us today about, make sure I get this right, the CISG and contract practice, facilitating negotiated terms. Nevena, it's a pleasure.
First of all, thank you very much for that kind introduction. And it is truly an honor and a pleasure to be here. And as other speakers did, I will start with thank you notes to both Professor Fleckner and Professor Brand for supporting a small community of arbitration and CISG professionals in Bosnia. We were the last ones to join the Pitt family, and you have done so much to provide support, provide us with an opportunity to learn outside of systems that are familiar to us and get us out of our comfort zone so we can learn and grow professionally and personally. So on behalf of all of us, I just want to say a warm thank you for being that light. And in my wildest dreams, I could have never imagined to be on a panel speaking after Professor Schwenzer, and also at the same time sharing panel with a close friend of mine, Janet Checkley, with whom I've worked on different projects. So it's really an interesting and a very exciting moment for me. As a lawyer, I've recently transferred to an industry-based association, and that has expanded my vision of what contract and contracting practices are. And as I was listening to the presentations yesterday, we were talking about what parties want and how does that fit within the CISG and how do we make it more appealing to them. And I would like to offer some insight of what is it that parties do in their contracting practices and where does CISG indeed fit within that picture, and what role can CISG play. And I would like to start, first of all, by introducing you to International Association for Contract and Commercial Management. I think this is very important to start off with because it will give you context of the relevant research that the association has been doing, which underpins my presentation today. So International Association for Contract and Commercial Management is a non-for-profit membership association. We have over 50,000 members, out of which over 19,000 corporations that come from Americas region, Europe region, and Asia Pacific region. And with all of that, we try to embed and share and establish a vision of a world where all trading relationships deliver social and economic benefits. We see contracts not just as a record of parties' rights and obligations, but also as a framework for aligning of interests so that they can achieve economic growth and have commitments that are ethical, achievable, and sustainable. Now that's the vision, but it is challenging to get parties from an ongoing practice where they are now to this vision. And one way in which we try to do that is through research. To identify and communicate, identify first of all current practices, but also communicate best contracting practices so that the parties can thrive and achieve that economic growth. And the report that I particularly want to focus on today is a report on most negotiated terms that IACCM has done for the 17th year in a row. And the data that we've collected in 2017 and 2018 comes from 2,173 respondents, contract and commercial managers working on these contracting practices around the world. And what they were asked to do or provide answer to was, what are the terms that they spent most time negotiating? What are the terms that they see as most likely to cause dispute in their relationship? And what are the terms that they see as most important for their successful relationship? So let's look at the most negotiated terms. Now, when you look at the top 10 most negotiated terms, you can see through the terms such as limitation of liability, indemnification, warranty, termination, liquidated damages, that parties are concerned or that they approach negotiations in a very adversarial manner. It's a reflection of a power-based approach to contracting where they seek to shield themselves from risk occurrences and minimize the consequences of those risks. And that's legitimate, right? That is, and the legal theory as well teaches us that this is something that we need to do essentially, or emphasizes this approach in negotiation. But this becomes interesting when we look at what are the most contested terms. And most contested terms, 5 out of most contested terms are not part of that negotiation. And there's the first paradox. If the parties identify terms that are most likely to cause a claim or a dispute and therefore affect their relationship, why not focus on those in their negotiation? And when you look specifically at what those contested terms are, you can see that a lot of those are very similar to the example that Professor Schwenzer mentioned. It is responsibilities of the parties, defining scope and goal of their relationship, contract performance, right? How do we invoice, late payment, delivery, and acceptance, all of those key elements of a relationship. And then it becomes even more interesting when you look at the most important terms. And the paradox becomes even more evident, where the most important terms are still ones that revolve around achieving a successful relationship through that identification of what the contract is, what is the scope, what is the goal that parties want to achieve, allocating responsibilities accordingly, and then getting into the actual performance of a contract. And I would like to point out here a specific term that you see, which is change management. Now, change management in contracting practices is that phase that comes in after the contract has been awarded. And that is the relationship that parties establish, how to address changes that will inevitably come to maintain that relationship. And this is often the most contested and the most important term, but it is not something that they necessarily negotiate. So we see a dichotomy between what parties identify as important against what they actually spend time and money on. And the data from the report has also been segmented by industry and by jurisdiction. And because we're talking about this in the context of CISG, I thought it would be interesting to share what the data shows when we're looking at it from jurisdiction perspective. Now, there's not much surprise. Civil law countries focus on intent and responsibilities. Common law countries focus on warranties and damages, and Islamic law countries focus on financial terms. But what is even more important, that when you look at what are the most negotiated terms per jurisdiction and compare that with the most important terms identified in the report, parties coming from French law base are the closest one to this idea of relational contracting or building a contract as a relationship. 8 out of 10 of those terms are part of their negotiation. And then on the other side of the spectrum is Islamic law, parties coming from Islamic law base, where they have only 5 out of most important terms are part of their negotiation. And I think the most important part of this report is the comparison of this data over a 5-year span. And what we see is that not much has changed from this dichotomy between most negotiated and most important terms. Specifically, the terms have been largely the same. The only term that made a jump in 2018 is data protection, security, and cybersecurity. And this is most likely because of course, GDPR that is driving everybody insane, but also because of new emerging technologies and the effect that they have on business. So although this term has been identified as important previously, it was only in 2018 that it jumped to a negotiated term. So what this data shows, or what this report identifies as a key, is this continuous battle, if you will, between seeing contract as a deal and seeing contract as a relationship. And in certain contracting relationships, having a deal is good. But in contracts such as services that are ongoing and revolve a continuous enforcement of a contract, having a relationship, a flexible, agile relationship embedded in a contract is more important. And this is not, getting from a deal to a relationship is not an easy term. Having a contract that defines or provides that robust framework is not easy to achieve, because it includes good drafting, right? Contract simplification. It includes specific specific type of wording that will allow parties to understand what their responsibilities are, and this agile framework that will allow them to adapt to whatever comes their way. So to add a level of complexity to this, the framework or environment in which these parties operate is constantly changing. To come back to technologies, the way contracts are managed, assessed, enforced is now impacted with blockchain, smart legal contracts, IoT, all of these technologies that are affecting how business is done. And it's not just affecting how business is done, it's also affecting the role of both legal and commercial side. So if we are in this rapid area of change, then the next question is, what role can CISG play to support the parties in this transition to a more relationship contract? So the first thing that I did is looked at the data and identified which parties coming from the law bases identified in the report are also contracting states to the CISG, and the vast majority of them are, with the exception of India. And then what terms that have been identified as most negotiated and most important and most contested fall within the scope of CISG, and with the exception of few, majority of them do fall within this framework. So CISG seems to be a fruitful soil for addressing these concerns. Now, the second question then becomes, is CISG suitable to address or support parties in this? And of course, because this entire panel here, I think, is here to praise the CISG, my answer to that is going to be yes. But it is not an easy task. And what I think, there are two reasons why I think CISG 2.0, and I'm not suggesting a new convention, and I'm not suggesting interpreting the convention beyond what it was intended to do, but what I am suggesting is of course, convention is a compromise between different legal cultures and traditions that inevitably impact negotiation. And if it is a compromise, then that compromise can serve the parties. It can serve the parties in reducing the friction that they have in their negotiation, so eliminate the friction in the negotiation terms, most negotiated terms, but also serve as compromise for their most important terms that are relevant. And that brings me to my key point, which is that changing the approach that we take when we talk about CISG. I think CISG can be used as a fair and balanced approach that allows the parties to achieve an output that reflects both their legal concerns and their commercial concerns. And I think we spend a lot of time talking about the legal concerns, and we need to bring in all of these contract and commercial managers, and there are 6.5 million of them on LinkedIn, registered as such, into the conversation so they can tell us what their commercial concerns are. When we understand what their commercial concerns are, then we can respond to them and say, there's this beautiful Article 6 in the CISG that allows you to vary the effects, not to opt in, not to opt out, but you can vary the effects of the convention, and therefore use it, address its weak points, and through your contracting, and leave the ones that you see best or most suited for your relationship in there. And I don't think this is a very radical approach. Given all the brilliant minds, legal minds in this room, I think this is achievable, but we need to also focus on education that Janet is going to talk about, and also have a flexible interpretation of looking at new trends that Professor Schwenzer has mentioned. And with those two things, I think we can achieve this goal. And with that, I think on time, I would like to conclude. Thank you.
Thank you very much. You made my job easy. I didn't even. All right, and for our final panelist, let me introduce Janet Checkley. I didn't know Janet before this particular event, so it's been a pleasure to meet her and get to know her. In fact, I discovered that we've got a common colleague in the area of enforcement of international mediation agreements. Janet's an expert in the field of international dispute resolution generally. She does research and capacity building, and she focuses not just on arbitration, which many of us tend to focus on because of the moot, but also on mediation and broader conflict resolution. And again, in keeping with this group, Janet teaches online graduate level courses in dispute resolution. So again, we've got someone else who has moved into the area of online education. And I think she's going to talk to us today specifically about the CISG and legal education. So great addition to this panel. Janet.
Okay, good morning. It's absolutely my honor to be here this morning. This is my hometown and this is my alma mater twice over. And I'm honored to have been invited by Professor Brandon Harry Fleckner to address all of you today about the CISG and the role of legal education in promoting the CISG. Now, I need to start with a disclaimer, which is that I am not by any stretch of the imagination an expert on the CISG. So there will be plenty of opportunities to disagree with me on some of the things that I'll present about my understanding of the CISG, and I welcome those corrections because I'm not an expert on the CISG. But what I think I can claim an expertise to is how to use different models of education to promote the CISG. So what I would like to do with my presentation this morning is to just step away from the text of the convention a bit and look at it instead from the time that it was adopted until today, from a development point of view, how has it done, and what is it missing in that regard? And I think the answer to that, just to give away the ending here, is quality legal education at all stakeholder levels of engagement. And I'm going to focus my remarks as I go along on one particular effort to promote the CISG through legal education, which is the Vismoot competition, where I have a particular vested interest. And I think that that carries potential going into the next phase of the CISG's life as it enters middle age, which is supposed to be, from what I understand, the best years of your life. I hope. I think that this particular model has a lot of potential, and it's something that we should look at very carefully to carry us forward into the next phase. So that's what I'll be discussing. But first I want to offer you my novices hypothesis on the model for development of the CISG. And if I accomplish nothing else in the next 20 minutes, then at least I coined that phrase, novices hypothesis. And Harry, if you ever start rapping about the CISG instead of singing about it, you have my permission to use that lyric in that song, in that particular rap song. So in my novices hypothesis, there are a couple of approaches to promoting the CISG as a model for contract law around the world. There are top-down approaches, and we can also consider those, if you will, supply side to the convention. And then there are bottom-up approaches, and we can consider those demand. And somewhere in that mix comes legal education. And by the end of my presentation, I hope that we'll be able to see where it fits in. So moving a little bit quickly, going through the top-down approaches, we start with convention drafting and adoption. And this is, of course, this stands to reason. We wouldn't have uniform contract law if we didn't have UNCITRAL to draft it for us. And this is where things really happen in terms of multilateral negotiations. The conventions are drafted along with other legal instruments. They go to the UN General Assembly for adoption, or they can be finalized by UNCITRAL if it's not a convention. And from here, ostensibly, this is where legal norms would flow from. So this is up at the top of this stakeholder engagement spectrum for promotion. This is where things begin. Moving along, we have further UNCITRAL engagement. So the work of promoting a convention certainly doesn't begin and end with drafting. It needs to go from there on to adoption and ratification and accession at the country and state level. And so for that, UNCITRAL does remain engaged. They include themselves in technical assistance for legal reform, capacity building efforts, and expert engagement. And then we move on to state-to-state engagement, and this is where countries work with each other to promote the CISG as a good commercial law for their merchants. And a really lovely example of this right now is the current dialogue unfolding in the ASEAN community, where there are efforts at regional integration to arrive at a harmonized system of international commercial laws, and the CISG figures prominently in that dialogue. And then finally, we have the critical role of the courts and tribunals in interpreting the convention's provisions. And of course, one key feature of the CISG is that it does not create a centralized court or body to hear and determine cases. The work is left to domestic courts and tribunals, and they can do that in line with Article 7. And in that respect, I would say that the CISG is rather self-unifying, because it does provide that guidance, and it's up to the courts and tribunals to follow that guidance from Article 7 and correctly interpret the CISG's provisions, or to do so in line with their national laws. But of course, there are some limitations to the supply side approach to promotion. First, UNCITRAL is a public body. It has limited resources. It's headquartered in Vienna, and this in and of itself limits the level of engagement it has to promote the convention. In addition, there are some cultural and linguistic shortcomings there. Milena pointed out yesterday some of the variations that can occur when the convention is translated out of one of the 6 official UN languages, so that can be quite challenging. This approach is also time-consuming and labor-intensive. It depends on conducive geopolitical and economic factors around the world, and the competence of domestic courts and tribunals to interpret the convention's provisions. And we heard a great deal yesterday about the limitations on the competence of many domestic courts and tribunals. And of course, within the convention itself, the self-unifying nature that comes with Article 7 is checked by Article 6. So we can't stop there. It's apparent just from that simple look that we need a bit more to get the convention promoted at the level that we would hope, so that it can achieve its purpose and aspirations. So we have to continue, and now we move to the bottom end of the spectrum, where we start with the market approach to the CISG. This is the user experience of the CISG. And we start with contract drafting, which Nevin so nicely just laid out for us. Parties can and do opt into the CISG explicitly, and they can and do derogate from the CISG and modify the effect of its terms. And they also opt in when they select the national law of a member state to govern the transaction. At the dispute resolution level, just as Article 7 makes the CISG a self-unifying document, Article 11B, in some sense, makes the CISG a self-promoter as well. And the role of the courts and tribunals here is in conducting a private international law analysis and correctly applying the results of that analysis when it leads to the CISG. In addition, we have case reporting, and this is voluntary. Cases can be reported to the cloud database, which is really a marvelous resource for users, and the CISG database, I would argue, falls into this category as well. And finally, there is the CISG Advisory Council, which is a private initiative to promote uniform interpretation, again at the user and dispute resolution level. So this is great, but of course there are limitations here too. First of all, this leaves a lot up to the users. And as we've seen from yesterday, John's presentation, Susan's presentation, and Nevin's presentation, users, contract drafters, and contract negotiators may not understand how best to apply the convention, opt into it, opt out of it, or use it to their advantage. And so leaving so much to the market in that sense is a little bit risky for the CISG. There's also the fact that the CISG faces stiff competition in common law jurisdictions, where drafters are much less familiar with the civil law approach to commercial law, and the CISG does resemble that. Within the convention itself, the CISG Article 11B is checked again by Article 6 and Article 95 declarations. Case reporting is voluntary and can be slow and inefficient. And as for the Advisory Council, given present company and that I'm in the presence of more than one member of the advisory council, and I'm sure that they could overpower me in a dark alley later today if they wanted to, I will keep my opinions about the advisory council to myself for now. They're perfect. So where does that leave us? Well, there's a gap. In my opinion, the top-down and bottom-up approaches to convention promotion, particularly with the CISG as an international instrument, don't meet in the middle. And in order to bridge that gap, we need dedicated international legal education efforts about the CISG, which have the power to inform every level of stakeholder and user engagement, from contract negotiators and drafters, advocates in courts and tribunals, judges, arbitrators, and adjudicators, and law and policy makers. So in terms of what legal education would look like, I've come up with a few artificial divisions about the types of education available to users and stakeholders, and roughly it breaks down into the following, and I'll keep this very brief. There's scholarly research, which there is a wealth of about the CISG. Thanks to the CISG database, even though it hasn't been updated since 2015, there are over 1,500 articles about the CISG on that database. Anyone who needs to access information about how courts engage with the CISG or how provisions should be interpreted can do so. In terms of classroom teaching, this is also an area of huge potential. The growth of the international LLM degree around the world has made it possible for students to access information about the CISG anywhere they go, as long as it's on the curriculum. And given this incredibly mobile student body, students coming from jurisdictions with no familiarity with the CISG can come to a jurisdiction like the University of Pittsburgh, learn about the CISG, and take that knowledge back home with them when they return to practice. One of the limitations to classroom teaching, however, is, and this is something that came up a little bit yesterday, quality control. We don't always know how good these teachers are. We don't always know how good the curriculums in place are going to be. Some of us, many of us here, are some of the luckiest people in the world that we were able to learn about sales law from Harry Fleckner, but not everybody has Harry Fleckner as their sales professor. And we feel very bad for those people. But we have to take into account that not all teachers are created equal. Not all teachers are as good as Harry Fleckner. And so there's much left to chance with the classroom model. But the one that I really want to focus on is practical legal education. And the example that I'm going to offer is the Willem Sevis International Commercial Arbitration Moot Court. And I'll do this through a case study. A few years ago, I completed a survey of our work in the Middle East that I'm lucky enough to do with Professor Brand. There we are engaged with a U.S. Department of Commerce funded project to train professors and young lawyers in the CISG and arbitration, and we use as our platform the Vismoot. And so this has attracted the attention of a number of international development organizations that wish to assist some countries to reform their commercial law and improve their environments for international arbitration. And the goal is actually not to promote the CISG per se, but to promote a conducive environment for international investment and transnational commerce. So in this respect, the CISG is regarded as a tool to assist that effort. It's not the final goal, but it is seen as one of the best models for international contract law on the market now. And so to look at this in the Middle East perspective, this is the list of current ratifications of the CISG in the Middle East, and you can see the uptake has not been strong in that region. Only Egypt, Syria, Iraq, Israel, Bahrain, and the state of Palestine since 2017 have ratified the convention. Now let's look at a timeline of participation in the Vismoot from MENA teams. So between 1993, which when the Vismoot was founded, and 2008, there were no teams participating from the MENA region. And then in 2008, Bahrain showed up. And that was the very first team from an Arab country to participate in the Vismoot. The following year, we added, or Jordan, the University of Jordan, added themselves. And actually this team contained, as far as we know, the first Arab woman to ever compete in the Vismoot, a good friend of mine. And then in 2010, we started officially, and sorry this is very small, but we officially put in place the first MENA pre-moot. So I'm sure everyone in this room is aware of what a pre-moot is, but it's an opportunity to practice with other teams that intend to compete in Vienna or Hong Kong. And it's a great chance to get your feet wet in competition, and there are a lot of them around the world now. And so we started the first one. Professor Brand took up the mantle with CLDP and started the first official pre-moot in 2010, and that year 4 teams from the Middle East joined the competition in Vienna. And from here, it grew. Every year, we've settled into an easy trend now. We can generally predict which countries will be participating. In 2018, last year, there were over 20 teams, I think maybe exactly 20 teams from the Middle East competing, and over half of them had received assistance from Professor Brand and the CILE, or through the Commercial Law Development Program, either that year or at some point in their past. And we include in our cohort here teams from Afghanistan who compete in the Vismoot-Ease, and teams from Iran. Even though these are Central Asian countries, they do take advantage of some of our training from time to time. And so Afghanistan has been participating since 2014, and Iran since 2015. And so what this means in practical terms is that you see again the list of ratifications compared to the list of participating countries, and most of the students coming from the Middle East who participate in the Vismoot do not have any access to the CISG as a national law. It's not present in their national legal system, which makes the Vismoot likely the only time they would encounter the CISG anywhere in their legal education. And so this actually elevates the criticalness of this kind of facilitated engagement. If future lawyers from this part of the world are to learn about the CISG, almost the only way they're going to do it is by coming to Vienna and competing in the Vismoot. This trend is apparent in other parts of the world as well. Southeast Asia is a good example. Only 2 of the 10 ASEAN countries have ratified the CISG, but there's almost universal participation in the Vismoot in ASEAN countries. Brunei and Laos are the exceptions. And that's again thanks in part to the development of the Vismoot East. There are a couple of counterexamples to this, of course. South Asia has low ratification and low Vismoot participation if you control for India, which sends a lot of teams every year, and they compete very successfully. And in sub-Saharan Africa, it's difficult to discern a trend. There's scattered adoption of the CISG and almost no participation. And I would suggest that, or participation in the Vismoot, and I would suggest that the reasons we see these 2, sort of difficult patterns in South Asia and sub-Saharan Africa is resources. These are developing countries, and it's difficult for them to get to the level necessary to get all the way to Vienna or Hong Kong. So in terms of advantages to the Vismoot as a pedagogical platform for the CISG, in the MENA region, there are a few to highlight. The first is that in relative terms, this is low cost for faculties. It's certainly less expensive than hiring a professor who can teach commercial law full time. It's labor efficient for law faculties as well. It's not labor efficient for students. They have to work very hard, but at least for the professors and for the law faculties, this is a good model in terms of labor and cost and time. The CISG, or excuse me, the Vismoot provides a forum for international exposure and engagement that many students would not otherwise have if left to their own devices in classrooms. And particularly in the Middle East, one of the exciting things about the Vismoot is that it promotes gender and cultural diversity among students who are going to matriculate eventually up into the practice of law. And this is really important in the Middle East, where we have seen some historical marginalization of women in the profession. But one of the most important things that I think we should highlight about the Vismoot as a pedagogical approach to teaching the CISG is its practical nature. This takes place outside the classroom. Students have to use their imaginations. Students have to think on their feet. Students have to delve into the study really closely. This is not theory-based, and although there is important theory involved with it, but in the Middle East, particularly, classroom teaching is very theory-based. It's mostly reading. It's mostly lecturing by reading chapters. And this, students reported in the survey that we did a couple of years ago, was the most valuable aspect of their participation in the Vismoot. And I think our Chief Justice in Singapore summed this up beautifully when he talked about the value of the Vismoot at the 25th anniversary of the CISG, or excuse me, the 35th anniversary of the CISG. He said there's no better way to become intimately acquainted with a body of law than through the cut and thrust of public advocacy. And this is so even when one is using wooden swords. So if we are to make the gradual transition towards a more harmonized commercial law, then our students must be exposed to international instruments like the CISG, and he was referring specifically to the Vismoot in that case. So my time is up. Let's revisit my novices hypothesis. So this is what it looks like. There's the top-down approach, the supply side, and then there's the bottom-up approach, which is the demand side, and here's where I believe legal education fits in. It has to inform every level of stakeholder engagement when it comes to the promotion of the CISG in order for the CISG to achieve its aspirations going forward into the next phase of its life. So looking ahead, what does that mean? Well, there are a few realities and predictions that I can make at this, realities I can observe and predictions that I will make. We will see how far they go. Of course, as it's been noted, we are facing a backlash against global trade and globalization. The CISG was conceived at a time that it was envisioned that we would simply continue down the path of increased harmonization in global commerce, and we're now we're questioning whether that path is going to continue in a straight line or if we're veering in another direction. But one of the predictions that I'll make in that regard is that this is simply an indicator of an even greater need for strong promotional efforts on the CISG so that merchants continue to have simple, reliable, and transparent means of doing business with each other in a very challenging global environment. The next thing that I think we should keep in mind is the Belt and Road Initiative coming out of China. This will transform our international trade landscape if it's successful. Because of that, I actually think this may mean very good things for the CISG. China is a big advocate of the CISG. Its national contract law is based on the CISG. And in order to help countries who are going to be part of the new Silk Road and the new Maritime Silk Road, we should have concentrated efforts at legal education in that trading belt to make sure that those merchants can take advantage of these opportunities that are going to be coming towards them to the fullest extent. And finally, we are likely to see continuing emergence of the Global South. This is almost as big as BRI is going to be. I think the center of gravity in terms of global trade and commerce is going to shift. And commerce is likely to stream in the next 50 years from what are currently called second cities. They're places we've never heard of, but their populations are booming and they're set to enter the global market with a roar. It would be great if we could ensure that they have a sophisticated level of cross-border trading capabilities by introducing them to the CISG now and giving them the tools necessary to engage meaningfully in commerce through the CISG. So that is my presentation. Those are my remarks. Thank you very much for your attention.
See if I can get us back to our, well, I think I have 2 minutes before our Q&A period is officially supposed to start, so I'd like to exercise my moderator's prerogative here and make a couple of quick observations, tying this panel back to Harry's talk last night. Harry explained to us, and makes a very great point, as someone who also teaches UCC Article 2 and has seen it go through from its earliest days to some level of success and uniformity today. That was done because parties didn't have any choice. If you were a U.S. contract lawyer, in fact, if you look at the conflict of laws principles embedded in Article 1, you could choose seller's law or buyer's law, and arguably that's it. So choosing a different body of law wasn't that easy in the United States. And so the thoughtful lawyer was forced to learn UCC Article 2 in order to vary its provisions effectively. It's all default provisions. You can vary them, but you can't vary individual provisions without knowing the body of law. So, tying that to this panel, it seems to me that what Janet is suggesting is that we need to do a better job of educating people as to the CISG, and all of us have certainly made great efforts in this room, but we need to do even better. I think that's what Harry called us to do last night, because if we can't force it on people, then we've got to somehow do a better job of conveying its value, long-term, and conveying alternative approaches. What we all teach, anybody who teaches the CISG, we teach them Article 6. You can opt out. What this panel is suggesting is that we can do better. We can teach them some other things about Article 6. Ingeborg has explained we can use Article 6, at least in most jurisdictions, to opt in to a transaction that the CISG wouldn't otherwise govern, whether it's between non-contracting states or whether it's a transaction involving services. We can opt in. What Nevena has suggested is, if we teach people to vary the individual provisions, that's the way they learn the CISG. Teaching them to opt out teaches them nothing about the CISG. But if we teach them to do what U.S. contract lawyers had to learn to do because they couldn't opt out of UCC Article 2, then they start thinking more thoughtfully about the CISG, what it provides, what it doesn't provide, where I want to contract around the default provisions, and where I kind of like the default provisions, and I get them for free, even if it is Machiavellian to sneak in a provision by using the defaults. So again, I think the panel gives us a nice opportunity to talk about how do we do a better job moving forward to take on the challenge Harry suggested last night of teaching people to make more of the CISG when we know we can't top down force it on them. So I'll open that with my comments.
If I was interested in Nevena's survey, the one area that I noticed wasn't included was dispute resolution, whether one was choosing arbitration or what forum. And some of us who teach IBT really put an emphasis on transactional planning, and so I was interested in whether it just hadn't shown up or whether that was not included in the design of the survey, or what you found from the survey as well on that.
Well, first of all, thank you very much for the question. And I'm going to answer it from the perspective of contracting lifecycle. So change management covers claim and dispute resolution as such. So when you look at it from that perspective, contract and commercial managers are not necessarily looking into courts versus arbitration. They see how to manage that potential claim or potential change. So the goal wasn't so much to focus on dispute resolution clauses per se or choice of law clauses per se, but to look at specific contract terms that tackle rights and obligations between the parties. Now, with that said, again, if you look at change management that covers dispute resolution as well, you can see that it is part, and it should be part of contested and important terms. It's just that it's not part of the negotiated terms, and that can be in line with general trends that we see, right? Dispute resolution clauses are often the latest one to be negotiated, at least anecdotally, and that should change as well. So I hope this answers your question.
Hi. I have one question for Nevena and one question for Ingeborg. All right. Hello. Nevena, so the people responding to the survey, were those lawyers or were those business people?
So they were contract and commercial managers. So with that said, a contract and commercial manager doesn't necessarily have to be a lawyer. And the report does segment the data between lawyers and non-lawyers. But there's not much difference between how they approach negotiated terms.
That's helpful. And Ingeborg, I have a question for you. So I was wondering if I thought your idea of having the CISG apply to service contracts was really interesting and provocative. And I'm curious, Janet gave us a very nice outline of how the CISG, sort of as it currently is constituted, could be, become widely known and spread sort of from a top-down approach or from a bottom-up approach. I'm curious, could you sort of take this opportunity to expand a little bit? Like, if people wanted to do what you're proposing and sort of expand it out that way, do you think a top-down approach would be more likely to generate that result? Would a bottom-up approach be more likely to do it? Sort of just talk through kind of logistically how you think the CISG could kind of be applied to more and more services contracts.
Well, actually, you might not know it. In 2012, Switzerland made an attempt to have the CISG applied to all contracts, or to develop a general antitrust contract law, which entirely failed. So, mainly because of strong, fierce opposition by the US. There was quite a lot of support from Asia, but also Europe. Like in the assembly, for the first time, Japan took the floor in support of the Swiss proposal, but the US influence is so forceful that it was not possible against the opposition of the US to pursue this idea. So I think, well, it's got to be a bottom-up approach, yeah, and maybe, I would be happy to work together with you, either on contract drafting or on legal education. I think that is the way we have to go forward, and that's promising.
Well,
following up on John's question, and Nevin, this I guess maybe for you, but it ties into the education aspect, because Janet, you were talking about educating new lawyers, but if we're part of the lawyer community, so we think the lawyers are pretty important, but most contracts get written without lawyers involved, and so maybe we need to think about the education of the people who become contract managers. Now, some have legal education, but the future might, in part, not come from lawyers who draft contracts, but the other people who draft a whole lot more contracts than lawyers do in many cases. Has your organization in the surveys done anything that would help us understand how aware those persons are of the CISG and the options in terms of applicable law?
So, first comment, and I have to take the opportunity to say this, but having talked to a contract and commercial managers and just generally business people, it is so fascinating to hear how they think about lawyers. I'm trying to understand, put a good word for lawyers, but it's just becoming very increasingly difficult, because they see lawyers as people who will always say no, and who will send them these contracts on tens of thousands, well, not thousands, but tens of hundreds of pages that just don't bring value to them. So I think there's an important piece there, which is communication between the legal and the procurement, well, buy side, sell side, contract and commercial management side, so that they understand what the commercial needs are and what the legal needs are. And I absolutely agree with Janet and with you that education includes lawyers. Lawyers need to understand commercial side. And I have realized through my work how important that is. That just wasn't part of my formal legal education or my legal practice. With that said, we do educate contract and commercial managers, and as part of our learning programs, we do cover CISG. But we have not done yet research particularly concerning the application of the CISG, which is something that I think we would very much welcome as a potential way to address this issue. And I think if we can, if result from that will be, here is how you can use CISG for your benefit, that they would be receptive to that. I surely.
If I could just add one other thought on that. I'm not sure how many people have heard about this, but on Monday this week, Loyola Los Angeles announced what I believe to be the first program where a law school online is delivering education, contract and commercial drafting education directly to end users, directly to contract managers. That's a little tricky because, of course, when a law school delivers that information directly, to some degree, we are devaluing the value of a legal education. We're going direct to our graduates' future clients. Of course, the spin on it from the dean at Loyola Los Angeles is we're creating more effective consumers for our graduates as future lawyers. But again, I think it's another data point when we talk about education that I think that there is, with U.S. law schools in particular, and with other legal endeavors, private, public, I think there are more and more of us thinking about how do we educate the end users and not just the lawyers.
Just a point on that. Here at Pitt, we do have a Master of Studies, MSL, a Master of Studies in Law for non-lawyers. And I think and they may be more focused there, but this is a general one, and I think it exists at a number of law schools where they can come in and take a year and focus on contract law that is useful in contract management, but without the need to be admitted to practice law. And that may well be a large part of the future of legal education, particularly in the United States with the declining enrollment in JD programs. And I don't know how much other law schools have thought about this topic as part of that, but certainly it fits into the general MSL sort of process.
Yeah, I think the only thing that's different is that this is a non-degree at all program. So it's just same concept.
Yes, thank you very much for the three excellent and very thought-provoking presentation. My question actually is primarily for Ingeborg Spencer, idea of extending, and I found it striking how much it was aligned, and very relieving for myself how much it was aligned with the idea that I have tried to convey in my paper. And I think we kind of fully agree on the result, the outcome. First of all, the idea that party could and should opt in, even in contracts that are not specifically sale contracts, and also the idea, by and large, that we should try to expand the application of the convention. The way to get there, however, it's very interesting. It's not a criticism; it's just a willingness to get your feedback and comments on some points that I pinned down. Because in a way, I think the starting point which can be shared is that the CSG to a large extent, and the draft of the CSG to a large extent, had general contract and obligation in mind. So formation, most of the provisions that are common to the seller and the buyer, many different provisions can be seen that way. But I still think that there might be some relevant differences between sales and services. Delivery, it's different from, and it was not among the ones that were listed, obviously. But even specific performance might be a little bit troublesome. Of course, the Germanic area applies specific performance not only to obligation to give something, but also to obligations to do something. But the French area, Italy, and other countries don't do that. They limit specific performance only to obligation to give something, not to obligation to do something. And the distinction, obligation de moyenne, obligation de résultat, still has, although we are moving even in services towards a more expanded role of obligation de résultat, but nevertheless, it's not the rule as it has become in sales. So given that maybe there are still some differences, and those differences may play a role, going to the CSG itself, into Article 3.2, I think your proposal was to read Article 3.2 and mixed contract as having a positive implication, meaning if the preponderant part is delivery, then you apply the CSG. Whereas my view is Article 3.2 may only have a negative implication if the preponderant part is not the delivery obligation. Then you cannot apply the CSG, because the CSG is meant to be applied with some other sources, which makes it maybe easier to say, well, and when you were saying, let's look at if parties distinguish and separate the two contracts, and they make a sale and a service contract as separate contracts, no one would doubt that the sale contract would be governed by the CSG. And maybe that should be the criterion to measure preponderance. The service is preponderant and the CSG cannot apply only if the sale would not stand on itself. And if the sale stands on itself, that means that the CSG applies, but it's not a positive implication, meaning the CSG applies only to delivery type or sale type of obligation without going that further step, saying that it applies to the entire contract.
Thank you very much. I think I was a bit sloppy on Article 3, Para 2. That was not my main focus. It was just to illustrate that the CISG is capable and suitable to address service obligations. I fully agree with you, and actually we have a CISG AC opinion on Article 3, where we addressed this discussion about preponderant part and all that, and we are working on two further opinions. One addresses the application especially of remedies in mixed contracts. So what you say, well, we have these obligations de moyens and it might not fit the CISG provisions, so we are addressing that, and I don't know the outcome yet. And the other one is closely related to this opinion, the question of distribution, framework contracts, and all that. So we are approaching this problem in the CISG Advisory Council. As I said, I don't know the outcome. I mean, even my dear colleague Michael Bridge, who is now the chair of the CISG Advisory Council, I discussed services contracts with him, and he said, well, there still might be a difference. I mean, from a common law perspective, common law that has always had strict liability in contract, he says, but in services we are not strict. That's a fault regime still. So I'm really looking forward to these discussions. Probably it will take a couple of years till we come up with these opinions.
Other questions?
Many thanks, Ingeborg. It's really fascinating to expand the CISG to further huge areas of law, actually. I have some doubts whether that will be possible without great additions to the CISG text. For instance, right of cure, think of a pure medical treatment contract, services contract. Will you really allow the doctor who has maltreated you to cure yours again? Probably not. Also, Article 79 is difficult for those contracts. I think that is a project for the more distant future and should be really pursued with great energy, I think. When we remember that Rabel started with the unification of sales law in 1928, I think it was, and how long it lasted, well, probably we will need years for that project, but I would support that very much. But for the present, I think we have the job to strive for greater acceptance of the CISG. That is what we have to address at the moment, and you both addressed that actually. And many thanks also for your contributions. I think it's very rational if the United States merchants insist on their UCC law. That's the same in Germany. If you can enforce your standard terms on the other party from another country, it's, so to speak, you have a home game. You are familiar with your own law and the other party is not. And if you can enforce that, it's an advantage and may lead to easier settlement of disputes and advantages for you. But in many cases, you can't anymore enforce your terms, and we talked about that yesterday. And especially in many many countries with less bargaining power than the United States, with less feeling of supremacy, it's probably necessary to do more than UNCITRAL still does at the moment to make the CISG not only known, but really to have trained lawyers in that field. The Wismut Court is a very good example for that and helpful, but each year, 1,000 people or so, we need much more to have a community of lawyers that accept the CISG, know the CISG and accept it, and enforce it if possible with their international trade partners. And I think in that direction we have to fight for the next future at least. And thank you for all your attempts in that direction.
Thank you, and I think it is now 31 minutes after the hour, so it's time for our break, unless you want us.
No housekeeping to take care of?
I'm trying to be on time, so thank you all for wonderful presentations, and thank you for your questions.
Dear friends, ladies and gentlemen, please take your seats. The next and final session starts. We are here actually in a courtroom, and one could imagine that behind us, or behind me here on the bench, there are the great CISG minds, John Honnold, Peter Schlechtry, and others. They are looking at us and asking, what will we do in future for the CISG, for the CISG? The first to have the floor is Petra Butler. She is a professor at the Victoria University of Wellington School of Law and director of the Institute of Small and Micro States, a very interesting task, I guess. And she specializes not only in commercial and business law, but also in human rights, a very important aspect of law in our times. Petra, you will speak about the CISG as a tool for successful MSME participation in global trade. The floor is yours.
Thank you very much, and I think, like everybody, I would like to thank the organizers for inviting me. Sorry, Harry, you know from last year I definitely can't sing. Otherwise, I would, in your honor, would have started my presentation with some song. But yeah, it's great to be here and celebrate your academic life with you. I think what I would like to do in the next, we're coming to this, no, I need another technique. Yeah. 20 minutes is, I think I would like to give you the statistics and the reason why we have talked about the CISG in the last day and this morning. I also would need to tell you that I think we're living all a little bit in a bubble. I think the people here, we are, in that sense, what you in English call sophisticated, because we know the CISG already. And I think when we have talked about some of the issues like opting in of the CISG, opting out of the CISG, we are already talking about sophisticated businesses. What I would like to talk with you about are the businesses what we would probably call not sophisticated. And I know that is in one sense, not a very nice label, but I don't mean it that, but I talk about businesses most likely whom I encountered in the research we've done. And this is what I would like to do. And starting with being an academic, and maybe somebody want to venture a guess. Does anybody know how many SMEs, as a small, micro, MSMEs, micro, small, and medium-sized enterprises there are roughly in the US? Anybody, students? So there's circa 30 million SMEs in the US. There might be 28 million, it doesn't really matter, there are heaps. And we contrast that with circa 18,500 large businesses. Now, what is an MSME? What is a large business? There is no worldwide, globally unifying definition because that depends what a large business is on the country you are in. What is unifying globally, what an SME is, basically is what percentage in each country they make from the entire business population, so to speak. So roughly, in each country, between 97% to 99% of all businesses are small and medium sized. So that means in the US, it's every business over 500 employees. In the EU, it's over 250 employees. In a country like New Zealand, it's every business over 90 employees. And if you go to Fiji, it is every business over 20 employees. So it depends a little bit where you are. However, what is unifying is they always make out the vast majority, as I say, between 97 and 99% of all businesses. So you need to see the percentages now also in light of this. So in the US, 48% of employees are employed by SMEs. That is worldwide also a trend that I have the next slide. You will see that it is roughly always normally about 50%. In the US, 79% of SMEs are owner-operators. So we have one person, and I think the definition includes then some, benign child labor by the children or the wife or the husband who don't count, but that means only 21% of SMEs in the US actually employ other staff, and this becomes important regarding capacity. And now we look at how many actually export, and this is roughly, if I got my math right, about 1%. So 287,835 is the last statistics I found. So why are we actually care now about SMEs? We could say, well, if that's the statistics, only 1% export. So why do we need to care? So we definitely do care about them because if there's if economists are clear about one thing is the only way states nowadays will raise their GDP, will basically erase, especially in developing countries, erase poverty is by getting the SMEs to trade cross-border. So New Zealand, for example, has a whole program called 2020 to get more of their SMEs to have a real push of SMEs to trade cross-border, and it's about 13% of all New Zealand SMEs trade cross-border, which is, according to the business world, a huge number already. Yeah, but the idea is to get even more. So basically, we can sum this up. Nobody cares about multinationals anymore. Governments don't, because they have their in-house lawyers, they're sophisticated, they can think about opt-in, opt-out of the CISG or any other choice of law. We don't really care about them, but we do need to care about the SMEs because we want them to trade cross-border to raise the GDP and with this the living standards of all of us. There is, and this is the basis basically, here's the source of this is where our research started, because there is research out there from the World Bank, the IMF, and the European Commission, and probably also now from us, that the uncertainties around the dispute management when trading cross-border prohibits SMEs to trade cross-border. And I'm talking about the research in a second, but just to give you already one statistical point, 58% of all New Zealand businesses have said in the study that the consideration how the dispute management would go actually is an important consideration by exploring a new market. And even in Austria, still 50% of all businesses have said exactly the same. Now, we did a pilot study in 2015 with 12 businesses. And the interesting there, what we found is we did interviews of 12, and we did at the same time a quantitative survey. And what we found is that the quantitative results didn't match the interviews. And this is because we lawyers designed, and the economists designed the survey. And as I describe it as what most businesses did in New Zealand, they ticked the first box in question 1, and the second box in question 2, and the third box in question 3, because they actually didn't know the questions we asked them. Because we asked, do you prefer litigation to arbitration? But that means already that the SME must have had the experience of litigation and arbitration to actually be asked to answer that question correctly. And I think from the work I've done now is that there are a lot of surveys out there that actually readers are designed without actually ever beforehand talking to the group. You're actually surveying and learning their language, because if you don't use their language, you don't get real results. So what we have done since is we have in 2018 interviewed a further 33 SMEs, and then also for very large companies, some which even under US definition would be a large company, just to see if we're looking at a cultural phenomenon or if it's just an SME issue. And we also did four Singaporean SMEs, and we're working on Singapore since then. But excitingly, we got colleagues from Australia, Canada, Spain, Belgium, UK, Hong Kong, and Singapore to do exactly the same. And those interviews and then surveys are now on their way. And in Austria, we have had the first results, the first kind of large interview results. We have plans to further research and include Africa and Eastern Europe. And sometimes stars align, so the Commonwealth, just really quickly, the Commonwealth Secretariat, which is this, the old English Empire, they just now initiated a study into international commercial arbitration and the use and the challenges there, and we could use our research results to actually inform their business quantitative survey. So using the language we have learned from SMEs, you need to use to actually get the results. And so in that, even though the focus there is mainly on dispute resolution and international arbitration, there are some questions in there that's all geared towards what other legal issues and what law issues. So we asked about choice of law clauses and so on. So that will complement the study quite nicely. So the only thing I actually want to go is to tell you actually before we start with the quotes, I will give you now just quotes. I will tell you and I will immerse you in this world of SMEs, what they actually say. And to start with, so what we found was, this is why it's so important that 79% are owner-operated in the US. Yeah? They are multitasking owner-operators. They are their own accountant, they are their own marketing, they are their own lawyer, they are their own everything, and in all of that, they have to provide a service or they have to manufacture a good, because that's what their primary business is. They don't use contractual documents in New Zealand. They have a complete knowledge about dispute resolution issues, for example, choice of law. They lack access of legal services, and they have a definitely tendency to self-hedge. So let us have a look. So this is one of my favorite quotes. Risk management and contracting with the US. No, because America, you know, you don't kid yourself. The Americans are not going to sue me. I could poison and kill an American with my product, and they wouldn't sue me because the lawyers would not make enough. They could take me to the cleaners, they could take my business, this is my favorite part, they could take my wife and children and sell them into slavery, and they would not make enough money to pay the lawyers' fees. Yeah? This is how you do risk management in New Zealand. Just to give you another example, because there was a question about dispute resolution, we had one SME owner who said, what do you mean arbitration? You know, who would go for this tree-hugging love fest? Yeah, it must be the first person who ever described arbitration as a tree-hugging love fest. So, which actually what I'm saying is I just don't know. Yeah? So, use of a single contract document. Well, it is a Saturday, so we can do more other quotes. For a layman like myself, even reading a legal document is already something. You have a bit of an idea what it says, but what it really means, you don't really know. Maybe even more important, this is what we find, is good relations are important to me. I'm not really interested in doing deals just for the sake of a deal. I would much rather work on relationships than signing documents, working on a level of distrust. So really important here, what we found, even coming up with a single contract document already basically signals distrust of the relationship. So what you don't have, we had SME owners who did their entire contracting via WeChat when it was with China, with WhatsApp when it was not with China. All sorts of really interesting, weird, and it's not that they don't have a contract, obviously, it's just not what we really would like and what we always tell our students, yeah? We have it nicely all written in one document. Just thinking back on the discussion we had at the beginning of the conference. A completely lack of awareness of dispute resolution issues, yeah? Let's look at the last quote. The obvious risk of international transaction is that if we have a disagreement, we have basically no legal standing. I'm sure we do, but I don't even know what it is, and it hurts my head to even think about it. And just one contract we saw or we've heard of is the way they did it is they had even a written contract document, and the way they did their dispute was, so if the seller was suing, they would sue in Australia, and if the buyer needed to sue, they would sue in England. That was their dispute resolution clause. And then in Australia, Australian law would apply if you sued in Australia, and if you sued in England, then English law would apply. Here comes in where Janet's presentation fits in nicely, the lack of legal advice. First of all, they don't have any money, so the profit margins are too small. But I think the other thing we've heard is, like, and this is now maybe New Zealand, but I'm sure I venture my guess it wouldn't be even that different here, is the legal education of lawyers who actually take private international law, who know about the CISG, who know comfortably about the CISG dispute resolution clauses, who can advise. In New Zealand, the only lawyers who would be able to give really good advice are the ones who are sitting in the big law firms, because they mostly have been at least a few years in London or New York. If you go to your rural lawyer, where those SMEs normally go for their property transfer, for the property, some company law advice, they don't know it either. Yeah? So that's what they told us actually. So well, if I go to my lawyer, I don't have the feeling that he knows more than I do. So legal education of lawyers is key here. So they're self-help. So obviously you mitigate it, you approach it differently, but the risk would be that it is much harder, or at least I perceive it to be much harder to enforce any payment. We just don't go there. It is sort of accepted in international transactions that there is a lot more cash on delivery, pay before it leaves. So you self-hedge, and the other thing is, so in New Zealand, and that's really interesting, if you were a seller, it was only selling after you got the payment. And I have no idea how they got this through, but that's what they all told us. And just to dispel another myth, we always, I'm sure we tell our students letters of credits are fantastic. In New Zealand, they all looked at us and said, too complicated and too expensive, and nobody uses a letter of credit. Okay, so I'm in an audience where I don't now tell you why the CISG is so important, and we can skip that part of the presentation actually. We have so if you look at the US, the good thing is the main export partners, China, Canada, Mexico, Japan, Germany, and South Korea, all CISG countries, so in a default position, and in that sense, maybe you don't want MSMEs to do any choice of law clauses because they are far better off, having none and have a fallback position of the CISG, I think is what I've heard. But here is also right. New Zealand as well as Austrian businesses have identified the US as a country that poses the most obstacles in doing business. Yeah, I just want to kind of share that with you. And so let's look at the CISG advantages. And with that, I'm actually not telling you anything new, but I think we should remind ourselves about it. It combines the best of civil law and common law. It creates a modern sales law, and not to forget, most of it, what we need, is actually freely available online. What is the best way forward? More research is needed, I think. More generally speaking, we need, as Janet said, we definitely need more education of lawyers if we want then, just in case they have a case and they need legal advice, actually lawyers who can advise them on the CISG. Between New Zealand and Australia, the CISG is applicable. Australia is New Zealand's foremost training partners, and anecdotally, and I think Ingeborg can attest to that when she talked to, like all years ago, to the New Zealand judges about the CISG, and they all looked in shock and horror, and since their judges are appointed from the bench, also from the legal profession, and I think they all looked and thought about all the cases where they should have applied the CISG, but they're either actually resorted to a New Zealand law or Australian law. So legal education it is, and with that, I leave you, and thank you very much.
Thank you very much, Petra. Our next speaker is Mark Walker. He is Principal Senior Global Practice Specialist at BAI Global. I'm guess sitting in Singapore. And he was the Singapore Director for the US Asia Pacific Economic Cooperation, APEC, before he took over his present profession. Mark, you will speak on the CISG and cross-border online dispute resolution. Please start.
Thank you so much, Ulrich. Let me take a moment and bring up my slides here. Okay, and sorry about this. Okay. That's working. Yes, thank you. I would like to thank everybody in the audience. This is truly a homecoming for me. I'd like to give special thanks to Marco and Francesca for paving the way for married couples to participate in the same conference. But especially I want to thank Ron for bringing us all the way home to participate in this. This is of the 5 that you've put together, this is, I think, my 3rd, maybe my 4th. And thank you, Harry, for the 25 years that I've been looking up to you and trying to be more like you. How different my life would have been without the 2 of you and the opportunities that you've given me over the years. I'm so very proud. I wanted to weave some things into this presentation that I've heard this morning and yesterday. So I'm just going to touch on a few little highlights to me that have some relevance to this presentation that I'm about to give. The CISG can be repurposed for use as a domestic body of law and for contracts beyond goods. We don't want to have to use a contract to buy a 6-pack and bananas. Courts don't always understand. The CISG is a cosmos, and Harry Fleckner is one of our most revered Cisco-nauts. The CISG bridges many different legal traditions. I was really taken by the savvy business person's response to John Coyle's survey, which I thought was probably the best response out of all of them. And it tells us something very important about the real audience and market for the CISG. The CISG is a legal product, and that implies that it has markets. We need more contract studies. Global value chains, especially when they involve faraway places like American Samoa, are risky. Opting out may be evidence of success of the CISG. Uniformity may be elusive. Maybe we need a uniform way of thinking about uniformity. I liked that one. I'm going to talk a little bit about all of this and weave a bit into into my presentation, so it's appropriate for me to be speaking nearly last. What can the CISG do for economic growth in a new era of trade? I've got a lot of ground to cover, so I've chosen to limit my presentation to some narrow topics. My message, though, is that the CISG can make huge contributions to economic growth, which is what it's supposed to be doing. Does this work? Yes. Trade is changing in ways that weren't anticipated when the CISG was being negotiated. In fact, it's changed rather radically in just the last 10 years. Just a few weeks ago, The Economist named this the era of slowbalization in a way that only The Economist can do. But I do have some reasons, I think, for being a little bit more optimistic. Smaller enterprises are engaging more actively in global value chains than ever before. Thanks to technology, micro enterprises are engaging in international trade really for the first time. And this is driving and enabling innovation. And innovations are often developed by micro enterprises, but need large markets for success, especially today. And then finally, countries, especially developing countries, are using foreign direct investment to create local content benefits for businesses more than ever. And while these requirements are by definition protectionist, they are building local capacity so that smaller businesses can engage in international trade. My career has taken me to a lot of places where small businesses endeavoring to engage in international trade are left with little choice but to treat the agreement like they're buying a 6-pack and bananas. There's no real formality to it. There are many reasons for this, but a core cause is the lack of access these firms have to access to commercial justice. Here's sort of how the hypothesis goes, or the logical progression goes. MSMEs doing business across borders lack access to justice. We know that. It's very poorly studied. Petra's doing a lot in order to try to remedy that. Enforcement of the judgment is uncertain. Costs are typically higher than the value in dispute. It's very hard for small businesses to engage in dispute resolution across borders. It's hard domestically. If contract enforcement is unlikely, then there's little incentive for parties to enter into these sophisticated contracts. The alternative to the sophisticated contract is relational contracting, bringing the quid and the quo and a quid pro quo relationship back together and doing things by handshake. The problem with these, especially in today's world and when the quid and the quo are separated pretty far apart, is that these entail very high transaction costs. Relational contracting is full of high transaction costs. High transaction costs and the market limitations that go with them attendant to the reliance on these trust networks result in barriers to entry. So what we end up with is the lack of access, and this is not the only reason, of course, that small businesses don't get involved in international trade, but we do see that the lack of access to commercial justice results in higher barriers to entry for these businesses to engage. And I think that's borne out by some of the stuff that Petra finds out. But as Petra so wisely said once, small businesses don't always know what they don't know. And that's an important feature to all of this. The solution is more contracts, more of a culture of contract, tying back into the presentations in the last panel. There are many ways of improving access to justice. One way is, of course, harmonization, which we've been discussing pretty deeply. Another way is to increase our use and access to litigation, arbitration, mediation. Litigation, some of the newer forms of litigation, like the Singapore International Commercial Court, so the commercialization of litigation. Technology in contracting, like blockchain, capacity building, and related regulatory reform. I'm told, by the way, that all good PowerPoint presentations now must contain the term blockchain at least once. Finally, what I'm going to spend the rest of my time talking about, and that's online dispute resolution, or ODR for short. I'm going to talk about ODR specifically in the context of the Asia-Pacific Economic Cooperation Forum, partly because it's become a popular topic there. It's also regionalized there. This is where a framework for ODR is being created rather than just some proprietary systems. And there are a lot of proprietary systems out there. Even counties in the United States, Franklin County, Ohio, is using a form of online dispute resolution. British Columbia is using a form of online dispute resolution, a number of other proprietary platforms, including for eBay and Alibaba. But I'm talking about this in a more institutional, multilateral kind of sense. So, what is ODR? It's completely fair for you to disagree with this. This is the definition that we've been using in the APEC context. It is a simple definition to use. There's more than one definition. The reality is we don't really know what APEC ODR will look like ultimately. I will say this, the multi-stage aspect is very important. It's not one thing, it's not mediation, it's not arbitration, it's not litigation, it's some hybridization of all of that, or it's none of the above. The important things are that it's about resolving disputes and it's conducted entirely online. And I'm not even sure about the entirely online part. I don't necessarily think that that needs to be a component of it. I want to touch quickly on the aspect that a lot of people think that ODR is automatically artificial intelligence. And that's not necessarily the case either. Because it's multi-stage, artificial intelligence will likely play an important role at some stage of ODR, but it doesn't need to be. And we're not ready for that yet. Or maybe Jack Graves will have a different opinion on that, but I'm not ready for it. In any case, it's ascendant right now for 3 reasons. Theoretically, and this is the most important reason, theoretically there's no dispute too small for ODR. You could resolve a $100 dispute using ODR if it's simple enough, convenient enough, efficient enough, and cheap enough. If you can resolve a $100 dispute for $5, why not? We're not there yet either, but it's in theory possible to do this. It's sexy. It is appealing to the legal community, or some of the legal community. It is appealing to the tech community, and it is appealing to the development community. The international development community is really liking this because it may give access to commercial justice to up-and-coming small businesses in places like Myanmar. I don't know why Myanmar is always my go-to example of a developing country. Finally, there's been a lot of momentum in the Asia-Pacific Economic Cooperation Forum. And here, I have to give a shout out to the very recently retired Mike Dennis from the State Department, who really, I'm kind of paraphrasing Ron Brand and saying that Mike took the ODR ball and ran it up the middle. He's been very determined about this. And I don't think we would have gotten anywhere with ODR and APEC if it hadn't been for Mike. I have to say very briefly a little bit about APEC. It's 21 economies. We call them economies rather than states because of the status of Chinese Taipei, which is the official APEC name for Taiwan, and Hong Kong, China. It's something like, these are not exact figures, but it's something like 50% of the world's population, 50% of the world's trade, and 50% of the world's GDP that is among this membership. It is a very diverse membership. Any club that includes China, Russia, the United States, Singapore, Peru, Papua New Guinea is not always going to see eye to eye on things. It's got the goals of free trade, regional economic integration, and economic growth. And happily for commercial nerds like us, commercial legal nerds like us, UNCITRAL, UNIDROIT, and the Hague Conference on Private International Law have guest status and regularly attend meetings. Sometimes, however, the most notable result at the end of the year is the fashionable family photo that APEC has become kind of famous for. That's the last of the family photos that I feel I can publicly display. One of the pillars of many. There are 70 committees and working groups within APEC. One of the pillars is the Economic Committee. Among such topics as competition policy, digital economy, and supply chain financing, the Economic Committee engages in structural reform, which is that new word that we got when Greece started to fall apart. Well, it wasn't a new word, but it was newly vogue. And that includes within that economic and legal infrastructure and the sort of ubiquitous ease of doing business framework that APEC takes as seriously as some others. The access to commercial justice and ODR kind of fits in that little sweet spot between where the overlap between economic, legal infrastructure and ease of doing business is. This is the evolution of ODR in APEC. I just wanted to highlight that there have been a lot of meetings. This has been going on since just about the advent of the the technical notes on ODR that ONCITRAL issued back, I guess it was probably 2015 when they were issued. And so we've been working on this in the APAC context since then. Did I lose my battery? I'm getting a very strange, yeah, it kind of locked up here. Oh, Walter, right there. This may be the biggest obstacle to online dispute resolution. Just go to slide 11. It'll probably lock up again.
Yep, it did.
Artificial intelligence doesn't do it for us here.
Either that or artificial intelligence, yeah.
Doesn't want you talking about it.
Yeah, if you just go to slide 11, then I can
Okay.
pick up right there. So what we ended up with in APAC was a very simple work plan on ODR, which has made some progress, but it's still a pretty sketchy sort of thing. First was building a pilot, an ODR pilot. This is something that, this is a bit, in a sense, outdated now, this work plan, because APAC can't build a pilot. APAC can't work with proprietary online dispute resolution platforms. It can't endorse mediation and arbitration centers. It is really not that kind of an organization. It's a multilateral national organization. Promoting harmonization, of course, that's a great one. It's one that we've already become engaged in. Collaboration across APAC, leveraging private sector and academic support. Petra and I have already started cooking up the idea of an APAC specialized center that could be a consortium of law faculties. Research and information gathering, which Petra is already doing. Designing a platform and a set of procedural rules, which is underway very, very haltingly. Building capacity. So you see a lot of the stuff that we've been talking about in the way of capacity building and education. And then finally exploring things like blockchain and smart contracting. There are 3 issues that are involved, or 3 challenges that we've been facing. Technology neutrality, which is something that's very important. Legal challenges and market challenges. I'm going to talk a little bit about the legal and market challenges. The technology neutrality part is not for this venue. It's important, obviously, but if I can't even get my PowerPoint presentation to work, I'm clearly not qualified to talk about technology in the way that we would need to. Just know that the technology's out there. It works. Ways in which we can overcome some of the legal and market challenges. And of course, legal challenges are really important here. I mean, we have lots of issues with due process. Can a machine provide due process? So lots of legal issues here. One of which I'm going to talk to you about in just a moment. We do have other areas where the CISG can really, so the idea is using the CISG as a set of default underlying rules for online dispute resolution. Lots of good reasons for that, as you can see quite easily there, and we all know what these mean, and we've all been talking about them. But there is one I'd like to narrowly focus on, because again, I needed to kind of narrow things down. There's one big ODR conundrum, and that is how to exclude consumers without excluding MSMEs. Why do we want to exclude consumers? because there are consumer protection laws in many countries that deny the right of consumers to waive their rights to traditional justice. And don't get him started on that subject, because we won't ever get out of here. And then there is so here, let me go back here just a second. In the drafting stage of the convention, the committee noted that in excluding consumers originally, of course, they had the same reason. There are consumer protection laws. But such an exclusion would not significantly limit the scope of application, since consumer sales would only in a relatively few cases qualify as an international sale within the meaning of the convention. That is all wrong now. Everything has changed. And in excluding consumers by traditional methods, you're casting a net that cuts out a significant portion of businesses that are doing trade across borders. However, the CISG, I think, offers a pretty good solution, and that is an exclusivity standard. Most tribunals and courts, use a standard that where declaring that goods must be intended for exclusive personal use in order to exclude a contract from the CISG. This established interpretation, applied in the context of ODR, will allow the benefit of online dispute resolution to extend to anyone using goods purchased even primarily for personal use. In other words, if I purchased my computer for personal use, but I'm using it, but with the anticipation that I would use it for business, there's no reason why the CISG should not apply in that case. Thanks. So, in conclusion then, the CISG as a set of default rules for ODR provides some additional certainty. We can talk about that more at any point. Simplicity for users. Education founded on the CISG it ties in very well with education founded on the CISG and promotes movement away from this relational contracting. And finally, tying it in with additional research into the way MSMEs engage in business and allow us to apply a body of law we now pretty well understand to a new and very, very large market. I'd like to conclude my presentation with a quote from the executive director of the Hong Kong APEC Trade Policy Study Group. He was speaking at one of our APEC ODR workshops, and he kind of mixed up a little metaphor here and said that we need to send entrepreneurs out of the trenches armed with more than baguettes. And I think that that's really important, because even without robust enforcement mechanisms, contracts that spell out the parties' responsibilities and how risk is to be allocated are less likely to be breached. And even if they are breached, negotiated settlements are easier. Further, courts and other dispute resolution mechanisms often do not work precisely because there is no demand. If the community isn't using contracts and is relying on trust and self-help in cases of breach, there's no customer base for litigation, mediation, and arbitration. Developing countries are littered with empty commercial benches and derelict mediation and arbitration centers because donors figured that if institutions were established, angry disputants would flock to them, and that just doesn't happen. The secret ingredient to ensuring the success of renovated dispute resolution systems is the establishment of a culture of contract. And there is little better method for helping communities understand contracting than with the help of the CISG. As somebody noted a little bit earlier, as somebody noted yesterday, the CISG is a legal product. That, of course, implies that it needs markets to survive. But as with any product, we cannot be passive with the CISG. We know it's a good product, and it's our responsibility to actively promote it. Harry and I were talking just before this presentation, and Harry mentioned that what we really are talking about probably is that we're at a step along the way. The way to what is the question. Where does the arc lead? And if you can imagine the relatively limited possibilities for the future of law and humanity, then if we manage to survive as a species, one day we will have a global commercial law. And it's very likely that unless somebody comes up with a better idea, this is the beginning. Is this the Magna Carta of global sales law that eventually will set us free? It's very hard to say, but it's very likely that the CISG will play an important role in that. Thank you.
Thank you, Mark.
Thank you.
I'm particularly glad that you mentioned the justice aspect of the CISG. CISG is not only a product that should be marketed. Coming from an old continent, I'm idealistic enough to think that it also improves justice, a better balance between sellers and buyers. And we should not forget that that was also one of the aims of the drafters of the CISG, especially with a view to developing countries and to the imbalance between the rich countries and the not so rich countries. Our next speaker is Ron Brand, and it would be a fault to introduce him here. Please, Ron, the floor is yours. And I think I will not apply these sheets here to you.
It wouldn't work. I'd like to begin by thanking the organizers of this conference. It's interesting being the last speaker of a day-and-a-half conference, and I note two things that are kind of interesting. One is we're running on time, and number two is we have almost as many people here as when we started, and that says something about the quality of the speakers we've had and the nature of the topic. Second point, today's two panels have been put under the rubric of the future of the CISG, and if you'll note, of the 6 speakers, 4 of them are women, which may well mean the future is female in this area. I'm going to talk about some aspects of what I see as a future. And I'm going to talk about what was on the schedule originally as applicable law and applicable disputes, but I think it's applicable forums. The UN Sales Convention is a little bit like domestic politics. What you see depends on where you stand. If we look at the number of ratifications, we find the number 89. That looks pretty good in the international sphere. That looks like a real success. If we look at private party use of the CISG, if we use the numbers John gave us, if we listen to Susanna and what her clients say about opting in, opting out, it makes the CISG look like a failure. But I think the truth lies somewhere in between. But then how do we then assess that truth? Moreover, are there future scenarios that might change the evaluation of the CISG? Can success or failure depend, at least in part, on what scholars, governments, and practitioners do with the CISG going forward? And can the future include new approaches to the use of the CISG? If the problem has been, in particular, getting private parties to choose the CISG as the applicable law, are there more appropriate situations for the use of the CISG? And we've already heard some suggestions that perhaps there are here. But the question as I see it is whether the role of the CISG can be something more than has transpired to date. In order to address the something more, I suggest that we consider in particular the relationship of the CISG with both choice of forum and choice of law, with particular attention to developing legal frameworks which may offer new opportunities for the CISG and change the ledger a bit on the success and failure side. Now, so let's begin by kind of going back and looking at what we've heard over the past day and a half and thinking about what tests might be applied for the CISG. And then I want to think about whether, looking forward, there are new tests. I'm going to suggest that talking about applicable law may not be the right thing to think about. We may really want to think about applicable forums for the use of the CISG. So how can we test success or failure? Number of contracting states, 89 ratifications, accessions, looks pretty good, right? Private parties, when they reject it, may look pretty bad, right? The CISG and development of domestic sales law. Vjosa Osmani's presentation yesterday showed us that the CISG has had impact far beyond just state ratification or accession and private party use. The text of the CISG has had very positive influence in the development of sales law, other than just in the CISG itself. Janet Checkley's presentation this morning about the CISG and legal education. The CISG has been an incredible legal education tool through the Vismut and otherwise. But as we look at it, I think we have to ask collectively kind of what really matters. What is the collective record and how do we take that forward? Now, I would suggest that we do look not just at choice of law, but choice of forum, and that matters. In other words, what is the particular place for the use of CISG? And now, the focus here when we say choice of forum looks at it from a dispute resolution perspective, okay? But my teaching has been founded in not dispute resolution, but transaction planning. And lawyers, I believe, should prevent disputes from the outset by helping parties draft good contracts. And if you do that, you should make disputes less likely. But you have to know the point of the outcome if a dispute does arise. So let's look at this. And if we think in terms of Harry's presentation last night, the CISG equation, at first glance, really appears to be one geared for success. Through the widespread ratification and accession of the convention, the CISG has become the world's principal default law for international sales contracts. It is also a neutral commercial law. It allows parties to avoid the uncomfortable choice of being subject to either the law of the seller or the law of the buyer. This appears to allow parties to choose either to avoid reference to choice of law in the contract because the law of the two states involved provide for the CISG, or to choose the CISG in order to avoid being subject to the law of the state of only one of the parties. Thus, there should be comfort with either allowing the state to choose the law as the default law or the parties to choose the law, which would be the CISG, and we end up there either way. Result, transactions costs should be reduced, right? But as Professor Fleckner indicated last night, that has not been the real equation. Rather, the equation is one which Harry described as a dilemma, in which a choice must be made between, on the one hand, educating all business persons and lawyers so that they are aware of the CISG and transactions costs then can be reduced. On the other hand, we have lawyers not educated in the CISG who choose the law they know over the law they would have to learn. And as Harry told us, that can be a very rational choice. The first of these options would be more efficient on a global basis, but the second is more efficient on a single transaction basis. And of course, contracts are negotiated and drafted on a single transaction basis, at least most of the time. If, however, we could start with a contract designed to work with the CISG, which does not have to be drafted from scratch every time, then perhaps we could move from second best to the ideal result. But as we discussed yesterday, Susanna Cook offered that in 2005, and the world has not beat a path to her door to use those documents. So does this mean that moving from second best to the ideal result is not possible? Well, I suggest that developments not in choice of law but choice of form might provide the path to some greater success for the CISG. In order to understand that path and those developments, I think it's useful to consider the various levels of contract value, and we've already been discussing that on this panel. At one end of the spectrum lie the very large multinational, multi-million-dollar contracts involving large companies, experienced legal departments, and experienced outside counsel, and the resources which should lead to a first best contract set of terms, right? These are the deals that are generally designed to include arbitration as choice of forum. Arbitration is the darling of international commercial transactions, largely because of the New York Convention and the ability to recognize and enforce both the choice of the forum and the resulting award. And with 159 contracting states, the New York Convention brings even more of the world together than does the CISG. If larger deals justify larger transaction costs, then it would seem that the first of the CISG equations would be applicable. Thus, the CISG as neutral law would be both an inviting and an economically possible choice, but it appears from John's statistics and his research on databases of contracts used by publicly traded, hence large companies, that this has not been the choice in either the United States or Canada. Whether the result holds in other countries is not yet clear, and no published studies appear to be available to date. Now, arbitration is the international home of party autonomy, and parties may choose both the substantive and the procedural law, as well as the specific individuals who will serve to decide any disputes. That allows the parties then to choose arbitrators who are well versed in the CISG if they choose the CISG as the substantive law. And the arbitration community has been heavily influenced over the past 26 years by the VIS moot. Okay? The process which has made the CISG a success as an educational tool can also serve as part of the process which leads to global understanding and a resulting reduction in transaction costs through the use of the CISG in cross-border transactions. Well, I'm not aware of any empirical study that can help either prove or disprove that this is actually happening. My own experience with the VIS moot training in the Balkans and the Middle East, as Janet has more thoroughly described it, offers anecdotal proof that strides really are being made in the right direction with this realm of contracts. The middle of the spectrum is where we find the middle-class litigants. It's this group that those of us who negotiated the 2005 Hague Choice of Court Agreement thought would benefit most from that convention. Like the New York Convention, the Hague Convention provides rules that both respect the party choice of forum and the resulting decision. While the Hague Convention has come into effect, that is the case so far only for the 28 EU member states, plus Montenegro, Mexico, and Singapore. China, Ukraine, and the US have signed, but not yet ratified. So it doesn't have the broad effect that the New York Convention has for arbitration, yet. Should a significant number of states become contracting states, however, the Hague Convention has the potential to level the playing field with arbitration. That would provide broader opportunity for enforceable choice of forum and make litigation a more palatable choice in international sales contracts. Quite simply, it would require that contract drafters give more careful consideration to the real differences, strengths and weaknesses of both arbitration and litigation when they make that choice in their choice of forum clauses. Now, just as the New York Convention has been a catalyst for the creation of arbitral institutions around the globe that then compete for arbitral business, we've seen the Hague Convention become a catalyst for what I call sovereign entrepreneurship, for the creation of international commercial courts. In fact, those courts have been created in Amsterdam, Brussels, Frankfurt, Paris, and Singapore, among others. Whether they will have real impact in replacing the current magnet courts of London and the Southern District of New York is yet to be seen. There's a long process that will be required in order to determine the results of that. You first have to have the choice in the contract, you have to disputes arise, disputes settled, and with the courts then, and one of the advantages to the courts would be that you would have a publicly accessible body of the decisions of that court that might then lead to more people choosing them in their contract. But that's a long process, and it's not going to happen right away, all right? If the Hague Convention gains wide ratification and accession, and if an international commercial court in a country which is a contracting state demonstrates efficiency as well as competency in cases applying the convention, CISG, then that could go far in encouraging parties to international sales contracts to opt into the CISG in those contracts. It could create a measure of success for the CISG, which so far has not occurred. It's going to take a long time, however, to find out if that happens. Now, perhaps the area in which success for the CISG has the greatest possibility of short-term increased impact is that which Mark has just discussed, online dispute resolution. As Mark has demonstrated, this is an area that is gathering a great deal of interest from both the private and government sectors across the globe. Its real development, however, I think, has been hindered by governments and advanced by the private sector. A good example of how the development of ODR has been hindered by governments, I think, is found in the agenda at UNCITRAL. Through its working group, number 3 efforts from 2010 to 2016 to prepare a set of procedural standards and substantive principles for ODR, UNCITRAL gave us an example of where the problems lie in this area. Early in that process, there were a lot of private sector individuals who came to the sessions for the negotiations. They had hope for success. But as the discussions continued, private sector participation diminished, and at the end, I don't think there was hardly any. That was largely a result of an understanding that the project was not going to have practical results. The process did not result in agreed upon standards, but was recorded in a record of the discussions saved in what has become the UNCITRAL Technical Notes on Online Dispute Resolution. During that process, though, at Working Group 3, the University of Pittsburgh School of Law Center for International Legal Education prepared 2 documents for that body. One of those documents was a draft substantive legal principles for deciding cases through online dispute resolution, and we distributed it in May 2011 at the negotiations in New York. The document provided a review of the process in the United States applied by credit card companies when there are disputes over credit card transactions. And under U.S. consumer protection law, rather than tell consumers where they can and cannot go, the law says, look, if you buy using a credit card, you have some recourse. And it sets up the credit card company effectively as the dispute resolution mechanism. So the CILE draft substantive legal principles reviewed the online dispute resolution procedures used by Visa, MasterCard, American Express, and Discover. The review disclosed that the number of types of substantive claims considered in each of the 4 systems was rather limited. Because the dispute resolution process was carried out within the framework of a finance system that involved accounts for both of the parties, remedies, too, were rather limited and simple, with the principal method of providing remedy being a chargeback by which the account of the merchant was debited and the account of the consumer was credited. The second document CILE prepared in that process was an official document of the working group negotiations requested by the UNCITRAL Secretariat. This was an analysis and proposal for uncorporation of substantive principles for ODR claims and relief. And in it, we proposed a set of core principles underlying a global ODR system. Those principles included that the system should be simple, efficient, effective, transparent, and fair. But to be simple, efficient, and effective, okay, it was noted that it required that the system be self-contained and avoid the need for reference to national rules of private international law. And that the system, in order to meet those goals, needed to provide for binding decisions. Now, based upon these core principles, that document also provided draft sample ODR claim and response forms for an ODR system. The failure of the UNCITRAL Working Group 3 may not really matter. The most effective ODR systems to date have not been created by states, but rather by private parties. Even a number of years ago, the eBay PayPal system of online dispute resolution was said to have been providing dispute resolution for over 60 million cases per year. That's a pretty effective record. Okay? Now, that dispute resolution system was tied to the finance system, and enforcement was generally automatic through chargeback arrangements, like the U.S. credit card systems. Okay? So how does this tie into the future of the CISG? Okay? As noted in the proposed principles for ODR, simplicity, efficiency, and effectiveness require that the ODR system be self-contained and avoid the need for reference to national rules of private international law. In fact, it requires reference to private international law. The CISG, though, requires reference to private international law in places like Article 1.1b and 7.2. But at the same time, by providing uniform substantive rules on contract formation and performance, it does significantly reduce the need for reference to private international law rules. It also provides a set of rules that is largely consistent with the more simply stated principles of claim and remedy suggested in the May 2011 CILE document presented to UNCITRAL. It also could be incorporated into an ODR system in which the 3 stages of ODR noted in the UNCITRAL technical note would be applied: negotiation, facilitated settlement, and arbitration. Now, that 3rd stage in the UNCITRAL technical note is not arbitration. It says simply a 3rd final stage. But I think it should be arbitration because I think there should be potential for a binding decision. And we, in our substantive principles, noted that. Now, If it's a binding decision, it would place it within the framework of the New York Convention. And while actual use of the New York Convention for recognition enforcement would not occur in the smallest transactions, the $100 transaction, the ability to have it available should increase actual compliance and reduce the need for enforcement actions. This third stage is the point at which it is most logical to have a single sales law governing all transactions so as not to violate the goals of simplicity and efficiency. That's where I think the CISG characteristics of uniformity and neutrality serve to make it a logical, exclusive law to be used in an ODR system. Now, so, conclusions. The Sales Convention has been available to states since 1980 and to private parties since 1988. It is nearly 4 decades now of its existence, 89 states as contracting parties, but at the same time, we hear that private parties prefer to opt out, okay? So the first point, the CISG has served as a source for the development of national, but we can look at success as national commercial law and how it has helped in other ways. But it's still too soon to declare the CISG either a success or a failure, I think. The ultimate determination of success will likely require both more time and the consideration of the applicable forum as well as the applicable law. There remains significant opportunity for success at 3 levels of international sales contract relationships, I think. Large contracts, often accompanied by arbitration clauses. Middle-class contracts that may fit well into the developing framework of the Hague Choice of Court Convention and the developing international commercial courts. And small and medium-sized contracts which lend themselves to developing area of online dispute resolution. But in the end, our hope, I think, should be that the equation for success is to be determined not by lawyers and business persons who do not want to spend the time necessary to learn about one more sales law, but rather by the role the CISG can play in providing both uniformity and neutrality in the developing legal landscape. I look forward to questions. Thank you.
Thank you, Ron. Now the floor is open for questions or comments. Yeah, John, please.
So hi. I'm really interested in the idea that the CISG could help sort of lower costs for small and medium-sized businesses around the world. And I guess I wanted to ask you more about the magnitude of the savings that were sort of possible through the increased use of the CISG. So from my understanding from your presentation and from the quotes you were putting up there, it sounds like many small and medium-sized enterprises, they don't want to be in litigation. In fact, they sort of have a distaste. They don't really want to be fighting this out in formal judicial proceedings. They want to work it out on a business-to-business basis or sort of work out some sort of negotiated settlement. So going to court isn't really their priority. They would prefer to avoid it. And once they're in court, I can imagine that the costs of litigating or resolving the dispute are going to be, a whole bunch of different costs. There's going to be the cost of hiring the lawyer and filing the things and the time spent doing this. And one of those costs is going to be obviously choice of law, right? If you have 2 different countries, which law is going to apply is going to be tricky. You have to research that. And obviously using the CISG reduces those costs. I mean, do you have a sense for the magnitude of that particular cost in the overall scheme of things? Like how important is that cost and how much can we really expect to save through using the CISG when it comes to these SMEs? Thank you.
I have to confess I can't answer it. Because Mark and I have worked in tandem a little bit, and I carved out the research we've done, which was mainly actually aiding that process of a dispute resolution system, because as you said, litigation is deadly for an SMA. But with it came the contract, how do they actually contract, what law they're choosing. And So to say, to be very clear, from my point of view, what I've heard, and if you look at SMEs, the best thing that can happen is that the CISG applies according to 1.1a, and nobody touches the choice of law, because that only can be a disaster. What I can say, though, if we would find a dispute resolution system that would probably combine the choice of law together with a unified dispute resolution system. The foremost economic think tank in New Zealand has estimated it would raise New Zealand's GDP about 1%. And I'm not quite sure, for me as a lawyer, when I heard 1%, I thought, well, what is this? But the economist, 1% is huge. Yeah? So any system which would unify the dispute resolution system for SMEs has that actually a great potential in raising GDP. But the choice of law would be one part of it, yeah? So that's...
Eric, please.
Thank you. Well, I wanted to answer the question, actually. Actually, Petra, you did answer the question. I can't answer the question either, except I would recommend that you look up this short little article from the 2003 convention by Kenneth Lane from Pitt Business School, where he kind of, it's speculation, but he kind of gives you an order of magnitude. It's not limited, obviously, to MSMEs, but it's a little bit of a start at any rate. And actually, well, because I have the microphone, I get to ask a question too, which is, I'm wondering about, and this kind of combines with Mark and Petra, how it works under the current legal system, the relational contract, the fact that people aren't doing anything formal in doing this. So my question really is in the relatively small number of international transactions currently being conducted by MSMEs, who are they contracting with? Are they contracting with other MSMEs, or are they contracting with large businesses where they will probably be required to sign a form? They may not want to introduce a contract document themselves, because that would be a sign of distrust, but they might very well accept, if I'm going to deal with a big company, I'm going to have to sign a form. And is there any information on that?
There's very limited information on it, but some of the bits that we do know, and I don't know the precise statistics, but when Petra mentioned that very large number of American SMEs that do business across borders, something like 90 to 95% of that is between the United States, exports to Canada and exports to Mexico. It's been NAFTA, really, that has made that possible. The other bit of information that we have is that, and this is one of the really fascinating parts, is that while there's a lot, you have to be careful about how you talk about MSMEs, because MSMEs include everything from subsistence farmers up to 499 employee businesses, depending on how you define the term. So what we really need is a new definition. Plus, we have this new term, micro-multinational, which is potentially a single person engaging in business multinationally. So it's a micro enterprise, probably usually subsistence, that's engaging in business abroad. But the typical small and medium enterprise that's engaging in cross-border trade that is not using a platform like Alibaba or eBay is a part of a global value chain. So there are small businesses that are in the Apple global value chain, small businesses that are in the Boeing and Airbus global value chains, which are very large. But the interesting thing about them is that they also tend to be doing relational contracting. They have actually created barriers to entry for other small businesses because they're sort of a trusted partner of the larger business going back years and years and years. And so they become very predatory or very protective and territorial of this area of small business that they've captured within a global value chain.
So they're not formalizing contracts?
Often not. They don't have formal contracts.
Can I add to that? I mean, there is a certain cultural difference, and this is why we're conducting this research all around the world, also to see where the differences are. I just want to add, I completely agree with Mark that it is definitely relational. Just to give you one anecdote, I interviewed a large business, 700 employees, so that would be even for US terms a large business. They had contracts. They had CISG arbitration clause, and they had a choice of law to New Zealand law. The in-house counsel said to me, well, the contracts are in the bottom drawer. In the last 10 years, we had not one single formal dispute resolution. So no mediation, no arbitration, no litigation. Because what we're using those contracts for are the springboard for negotiations. And I think what I also would really like to impress, for every single SMA or MSMA you see for arbitration, or let's say a lawyer sees, there will be 200-300 out there with a dispute which will never reach a lawyer, will never reach any formal dispute resolution. So even big companies negotiate, as I think. So that adds to Mark's point, I think.
Yeah, there's another question.
Yeah, I had a less substantive question, but after the last two presentations, thinking about the future of the CISG and technology and artificial intelligence, I couldn't pass up the opportunity to ask about robots. As we see increasing automation throughout the trading process, whether that's packaging, fully automated ports, driverless cars, maybe at some point, unmanned container shipping, where the technology for all of those processes is housed somewhere else, is conducted somewhere else, unrelated to the contracting parties. How does that affect the relevance of the CISG in the future? Is it an opportunity to promote the CISG, or will that have a diminishing effect on the relevance of the CISG?
Who will answer? Ron.
I think it creates a huge opportunity for greater use of the CISG. If you think about that, and we've actually had some discussions within some of us in the law school here about that. If you start with not just the text of the CISG, but what had been a really good database on that, which has been, because of resources, allowed to deteriorate over the last couple of years. But if you add to that some really strong artificial intelligence experts and education system in which you can use students to train to use that database and use the searches and then use the system to keep improving that, but you then tie it into the contract process. And I think there's incredible opportunity to work from the contract formation process with a sort, not just smart contracts that are automatically negotiated, but with sets of terms that are there through the performance to the dispute resolution in a system. And if you tie it to, if you could tie it to the database and a system that uses artificial intelligence experts like we have here at CMU and in law at Pitt Law, I think there's incredible opportunity, because the only way you can make a system like that work is if you have a single set of legal rules. Mm-hmm. And the only agreed upon single set of legal rules in the world for sales contracts is the CISG. I think there's huge opportunity in that. I think there's entrepreneurial opportunity. I don't understand why banks aren't getting into this, because they could be the capture the finance for the whole thing, and it would be an amazing system from contract to dispute resolution to automatic enforcement, because everybody would have to have their accounts with them. There's incredible opportunity, but I think it all leads back to the CISG.
Further questions? Yes.
Yeah. So thank you. And I would just like to, I know I'm not part of the panel, but I would like to add to this comment, because I've been working extensively in thinking about how to use these technologies in context of dispute resolution. Now, what is an increasing, well, not a problem, but realization that is going to show and become a challenge for this transition? I agree with you absolutely that a set of rules, a uniform set of rules is an advantage. But at the same time, we have translation problems, because that is something we need a set of, we need to translate the CISG into code, right? We need to, or understand, not contracts into code. And if we need to align that with CISG, that is a translational problem. And that is something that is going to be challenging in the future, especially if we take into account that these contracts will become self-automated and enforced. And dispute resolution, I think, in that context is also going to play a crucial role, because I see it being integrated in that process completely, and we will see a system where, you know, the platforms will look quite differently than they do now. And for us who have been raised and trained in an analog world to suddenly start thinking how to translate that into a digital world is fascinating and challenging. So I hope this helps in your thinking. Thank you.
Petra, you also will
Can I add a little bit to that thinking? If we come back to our little MSMEs, in an environment where they do relational contracting, when it's all about trust, when 79% of the SMEs in the US are owner-operated, it is very unlikely at the moment that they want to sit in front of a computer, because a computer screen is not relational, and they don't have the time and the headspace to sit out and type anything into a form. I'm not, as in New Zealand, only 56% of all SMEs even have a web presence, and they're not even save their files in the cloud. So I'm not saying it's not happening, but I think if we do this, then I think we need to be very creative to make it easy for them to actually use this and make it user-friendly. And this is, I think, you do the research first. What do they want? What do they really need? How do they really operate? And then think about the system you can actually assist them, you know, artificial intelligence, data, whatever. But I don't think that lawyers or multinationals are the prototype of people who use those systems.
If I look at the watch there and at our agenda, I see that's now time for closing remarks. I think maybe one more question. I overlooked you, sorry.
This question probably pertains to ODR, but it also can pertain to the service contracts we discussed earlier this morning. How do the rules of professional conduct factor into your analysis?
Thanks a lot.
That's the next symposium.
Yeah, because it does have clearly a big impact. I mean, I mentioned only one of the really critical issues that are involved in, say, ODR, and certainly in the area of services. And I thought Ulrich's sort of sobering example of a medical services contract was really interesting. I hadn't really thought of it in those terms before, but aside from the due process problem of allowing a machine, for example, to make a legal decision for you, there are all kinds of legal practice problems. When you're doing something in the ether, when you're conducting a mediation or arbitration in the ether, where are your lawyers? And where are your lawyers practicing? What law are they really practicing? What are the conflict of laws rules? These are issues that are going to loom large, very large. We've got multidisciplinary practice issues. When we've got companies like Modria, which are doing large-scale ODR, but also seemingly engaging in the practice of law. It's a prickly situation, for sure.
Before the closing remarks, first, a strong applause to our panelists.
And as first, a couple of housekeeping things, and as to closing remarks. Jacob, I wish that question alone was enough to qualify for at least an hour of ethics credit for those who are here for CLE, but I'm afraid the one question and the one answer won't get us there. I do want to note that in that regard, those of you who are here for CLE, hand in the 2 forms on your way out the door. And the final housekeeping matter for speakers. Right here to the right, there is a quick lunch for everybody. For those who are going to Falling Water, we'll then go up to the bus and go from there. So I think that's it, Austin, for housekeeping. In that case, I want to close, and I want to begin by saying thank you. I want to say thank you to Austin and to Rick and to Kim and to all of those who have worked with them to make everything run so smoothly. It's made it easy for the rest of us. Thank you to the speakers. I think it's been not only a neat group of friends to get together, but an amazing group of providers of intellectual content. It's caused me to think about things I haven't thought before, to think in new ways about things I have thought of. And I think that it's just been a remarkable day and a half of conversation that I think will have impact beyond a day and a half. So thank you to all of the speakers for joining us here. Thank you to those of you in the audience. I mean, it doesn't help to have speakers unless we have people there to listen to us. It's been wonderful. I do want to say thank you to the Journal of Law and Commerce. Nick Bensich back here is the next editor-in-chief, and which means he's the one who's going to take this the step further. And our first 4 conferences have all led to publications that I think have created a record that's made a difference, and some of the stuff, as Harry just indicated in response to questions, there are great pieces in those that are still quite useful. I think this is going to generate a set of articles that will be well worth being reviewed by many. So Nick, thank you to you and your crew for the work you're about to begin. We really do appreciate that a great deal. Finally, I want to say thank you to Harry. Not thanking you for retiring, because I wouldn't do that. But thank you for, by retiring, giving us the catalyst to all come together and have this fruitful discussion, and to not just have it as a discussion, but have it in a way that honors you and the contributions you have made over a career to this area of law. And we very much appreciate that. So we'll see you all at the 6th conference on the CISG here, whenever that will be. Thank you.
Thank you.